Good morning, and thank you for joining me on the Path to Liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the Fast Friday edition of the show for May 20th, 2022. And on this episode, I'm talking about one of the most abused parts of the Constitution, the Necessary and Proper Clause. But I'm going to focus with a quick take on the word necessary. To people like Hamilton and Chief Justice John Marshall, necessary meant merely convenient. But on the other side, well, that actually, I think, helped create the largest government in history, that kind of a view. But on the other side, we've got people like Thomas Jefferson and James Madison who told us that necessary means, well, necessary. I'm going to get to all that in some detail in just a moment, but first of all, I want to say thank you. Thank you for spending some time with me today, whether this is your first episode here or you've been here for every single one since day one. I can't thank you enough. I'm extremely grateful for you spending some time here and for watching the show. But since it's Fast Friday, I promise to not take up too much of your time. Let's see if I can get this info out to you in the next 10 to 15 minutes. I want to start out with an introduction to this by T.J. Martinell in an article we just published yesterday. And he said one of the most significant and often abused clauses in the Constitution is the Necessary and Proper Clause. Just reading it for you here. The clause states, "The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof." And TJ puts it this way, like if you're just reading it, it seems pretty straightforward. He said, on the surface, it seems straightforward. Simply put, Congress possesses the means necessary to carry out its powers, authorized by the Constitution itself. But there is a question. What constitutes necessary? How is necessary defined as ratified by the people of the several states? And to get into that a little further, Randy Barnett, and this is what TJ is giving an overview of this great law review paper by Barnett from some years ago, the original meaning of the Necessary and Proper Clause. And he points out that the clause was added to the Constitution in the Philadelphia Convention by the Committee on Detail without any previous discussion by the convention. Nor was it the subject of any debate from its initial proposal to the final adoption of the Constitution in September of 1787. Now, we do know that there was an earlier version of it that would have been much broader. They rejected that and went with the more narrow Necessary and Proper Clause. Narrow sounds funny when we look at how it's used today. But anyways, he said the likely reason why the clause received no attention became clear during the debates in the ratification over its public meaning. Their opponents pointed to this power as evidence the national government had unlimited and undefined powers. But he's saying basically they weren't really debating over this in Philadelphia because everyone basically agreed what it meant. And that was that the Necessary and Proper Clause, Randy writes, was not an additional freestanding grant of power, but merely made explicit what was already implicit in the grant of each enumerated power. And that's the same view that the Federalists took regarding the 10th Amendment. The structure of the Constitution was already written like this, we were told by people like James Wilson and others, and they just added it on there really to hammer it home. And I think possibly the best Federalist view on the Necessary and Proper Clause probably came from Edmund Pendleton in Virginia. And he said the plain language of the clause is to give them power to pass laws in order to give effect to the delegated powers. So without passing, basically necessary to those delegated powers. We saw similar statements from George Nicholas, James Madison, James Wilson, Archibald MacLean, and many, many others. Now, maybe they were just too confident. They were too confident in being able to explain this because there was some heavy anti-federalist opposition, like Barnett pointed out. And I think the best summary of what those takes were comes from John Williams in the New York Ratifying Convention. This is in June of 1788. This is the first one's on the 26th, back-to-back days here. He said, "It is perhaps utterly impossible fully to define this power. Necessary and proper. What does this mean?" They were concerned that it would be whatever Congress deemed was necessary or maybe just merely convenient. And then they were told, no, that's not what it means. No. You're getting it all wrong. Here's Williams again, June 27th, the following day. He says, "Whatever they judge necessary for the proper administration of the powers lodged in them, they may execute without any check or impediment." He was warning of an unlimited power in Congress because of the necessary and proper clause. And again, the Federalist supporter said, no, this is not a grant of new power. You shouldn't worry about this. We understand why you're arguing it, but here's why you're wrong. And so it was ratified under that understanding. Now, there is a conspiracy kind of take here that maybe some members in the Philadelphia Convention made it intentionally ambiguous so that both sides later on could argue for their favorite interpretation. At least they knew that they would never get it ratified by basically coming up with a clause that meant Congress can do whatever they think is convenient or necessary to do whatever they think is proper. That would never get ratified. You got a place like Virginia where ratification passed by like 10 votes. It was very close in New York. It was close in Massachusetts and elsewhere. They would not have gotten this passed. So there is a take, and I'm not sure how real it is. It is intriguing that maybe it was done intentionally, so let's get back to this later. Anyways, the best way to actually look at that might be Alexander Hamilton, the great flip-flopper. Here he is in Federalist number 33, and I know you can read this narrowly or broadly, but he's basically saying that necessary and proper is only declaratory, just declaring what was already understood. And he goes further. What is a power but the ability or faculty of doing a thing? What is the ability to do a thing but the power of employing the means necessary to its execution? So it certainly sounds kind of limited in scope, at least the way it's being sold by Hamilton. But once the Constitution was ratified and Hamilton wanted a national bank, man, that's a whole nother story. All of a sudden, necessary wasn't described so limited. It was described a bit differently. And here's how he put it. Necessary often means not just necessary. That's my add-on. Necessary often means no more than needful, requisite, incidental, useful, or conducive to. Necessary suddenly just means conducive. It's helpful. It would be useful, but not necessary. Necessary just doesn't mean necessary anymore. It is a common mode of expression, Hamilton said, to say that it is necessary for a government or a person to do this or that thing. But necessary doesn't mean necessary in that situation when it comes to government power that you want to expand. It means whatever you want. Convenient, that is. And this was repeated years later by Chief Justice John Marshall, McCulloch versus Maryland. He basically took the same view. Necessary frequently imports no more than that one thing is convenient or useful or essential to another. Now, if you and I were talking about, well, it's necessary to have enough money in your bank account before you can pay your rent, does that mean it's just useful to have it? And can you get away with paying for your rent without actually having the money to pay for the rent? I mean, this only works for people supporting the monster state. Now, this view from Hamilton and from John Marshall that it necessary means convenient is really the only one that law students are taught. Necessary is convenient. Almost every casebook, and I've only heard of maybe just one or two, otherwise, on constitutional law, they use this definition. They use this approach because it's the great Chief Justice John Marshall and McCulloch versus Maryland, and so therefore it's settled law. Almost all of them, on the other hand, ignore that there was an argument against this from Thomas Jefferson and James Madison. So people come through this system and they're the ones talking about the law, and they're the ones that go into office and they have this legal training. They're the experts. They're all telling us that necessary means convenient. Hamilton said it. Washington signed the bank bill. Marshall agreed. End of story. That's the way it basically goes. But here the story continues. And here's James Madison's speech against Hamilton's view on the bank bill. This is February 2nd, 1791, and he's talking about necessary and proper. He said, "Whatever meaning this clause may have, none can be admitted that would give an unlimited discretion to Congress." None. So if you're going to look at the necessary and proper clause, however you may define it, as long as you're not defining it to give Congress unlimited discretion, unlimited power, basically, then maybe you're on the right track. Now, if convenient to Congress, especially in the long run here, doesn't count as unlimited discretion, I'm sure nothing does at this point. But wait, there's more. Madison goes on. He says, its meaning must, according to the natural and obvious force of the terms and the context, be limited to means necessary. He highlights necessary to the end, necessary to the end, and incident to the nature of the specified powers. He's actually referring to the legal doctrine of principles and incidents, which I'm not going to talk about right here, but it has to be necessary. To Madison, necessary meant necessary. And going further in that speech, he actually rejects the idea that necessary means convenient. He talks about them in separate terms. He said the proposed bank could not even be called necessary to the government. At most, it could be but convenient. So he's recognizing that necessary and convenient are two different words with two totally different meanings. And when you're talking about powers delegated to the government, if you're trying to import one meaning on another, you're basically trying to expand power. Thomas Jefferson hammered this home by reiterating this as well. He said, the Constitution allows only the means which are necessary, not those which are merely convenient for effecting the enumerated powers. Again, I'm going to read that one more time. The Constitution allows only the means which are necessary, not those which are merely convenient for effecting the enumerated power. He warned that that kind of a construction, that kind of a reading, in that situation, people with power could torture into a convenience basically anything. And that's what they say today. They're not torturing it. They're just saying, well, this is what's authorized. And here's how Jefferson summed it up. He said, the Constitution restrained them to the necessary means. That is to say, to those means without which the grant of power would be nugatory. So in other words, if you don't have this additional power, you can't even exercise the delegated power. And maybe another episode, I can go through some examples of what that might mean in practice. But for now, I hope you enjoyed this episode. I hope you learned something. That's more important than anything. I hope you have a great weekend ahead. If you support the show, please consider a donation or supporting us as a member. You can join us for as little as $2 a month over at 10thamendmentcenter.com/members. Other things that help out are things like leaving a review on Apple Podcast, smashing the like button, leaving comments. All that stuff will trigger algorithms of the platforms. And of course, we will reach and teach more and more people about the Constitution and liberty. Again, thank you so much for spending some of your time with me today. I hope you have a great weekend, and I'll see you next week here on the path to liberty.